Good morning. Welcome to All Things Marcellus with me, Attorney Doug Clark of the Clark Law Firm. My office is located at 1563 Main Street in Peckville. I am here every Sunday from 8 to 9 a.m. to provide landowners valuable information that you need regarding the Marcellus Shale development. If you are interested in landowner information, this is the radio show for you. Of course, I represent landowners and only landowners, and if you need any representation, you have questions, you have agreements, things like that, you can always contact my office directly at 570-307-0702. I represent landowners for such things as gas lease negotiations, pipeline and water line agreements. We're going to talk a lot about pipeline agreements today. We have, of course, the royalty deduction issue. Is the gas company taking unauthorized deductions under the term of your oil and gas lease and addendum? Doing a lot of work of that. I think we now have over 160 individuals we're representing in our cases against Chesapeake for inappropriate or unauthorized deductions, what we feel, under the terms of their oil and gas lease. And doing a lot more of estate planning work, as many of my clients who we've represented in the past for leasing and pipelines and other agreements are now transitioning into the royalty phases of their leases. So that's a pretty exciting time. And a lot of people are saying, okay, now I'm seeing that this is actually happening. So what we want to do is we want to make sure that you have a plan in place. A plan that's going to work for you and your family. And I say every time, and I can't say these estate planning statements without saying how important it is that you, as the landowner, have a plan for you. Not a plan for your neighbor, not a plan for the guy in town, not a plan for the guy who lives in another area, or your neighbor that has a few kids and you only have one or two, or they have five and you have none, whatever that case may be, your age, all of these different things, the amount of acres you have. Everybody comes in with a different life experience and a different life situation. So it's absolutely critical that you have a plan designed and tailored to you and your needs. And it's important as ever when you're in this gas development to try to understand and get a perspective as to what can you expect reasonably moving forward. And I can tell you, when I talk to my clients, we sit down and we go over these things, one of the things that I say to them right off the bat is, look, I can't tell you with any certainty. Nobody can tell you with certainty. And I always say to my clients, well, if somebody's telling you, and this is with a lot of things, something with certainty, there's one of two things that's occurring. Either they are lying to you, or they don't realize that they're misleading you. So we want to make sure that you have the best information, that you can get the best guidance we can to help you along and say, okay, what's going to be the right plan for you? Because a lot of people out there have these Cadillac and even Ferrari type plans, and they just don't need them for their situation. But of course, in some circumstances, we're starting to see people, they're getting these first checks and they're saying, holy heck, this is a lot more than what I thought. Now, that's a great problem to have, but we want to make sure then that, you got your situation covered, that you know what you're doing. You want to make sure that if something were, God forbid, to occur, that you have the planning in place, and then down the line. And also, I say this often, we want to have a plan too that's tailored to you, but also that can grow with you, or you can change in the future. Sometimes I'll say we'll walk up to a more complicated plan, not just jump to the end because maybe you don't need it now. But as time changes, maybe there are more royalties than what you anticipated, and it's a better time for you to go ahead and say, you know what? We started off a little slow. We had something pretty basic, but at this point, maybe I need to change or alter my plan because I'm getting more income than what I anticipated. And again, what a great problem to have. I am Attorney Doug Clark. You're listening to All Things Marcellus. And a reminder, we're here now every Sunday from 8 to 9 a.m. And what I'm doing too now, this is a kind of funny thing. Here we are coming into end of May and towards the beginning of June. And what we do, we have the radio show, we archive it on the websites. And you hear me say this all the time. You can go to pagasleaseattorney.com or pipelineattorney.com. You can go to either website. We have, I think we're closing in now on about 150 shows. I've been doing the show since August of 2010. So we have about 150 shows available or thereabouts. So what we're doing now is, we switched stations recently, wanted to get out to more people in the Marcellus Shale region. So what we're doing now is I have these show and we're archiving and we're putting up on the website at pagasleaseattorney.com. We're putting it up the next day. So Monday morning, we're getting the show up there. Now, as we were doing this transition, we had a couple little technical difficulties, and that's a word that kind of drives me crazy. But we're getting the shows up, and I think we got it licked now. So we're getting the shows up the following day. So if you can't listen in every Sunday from 8 to 9 a.m., you can go back, check out the shows during the week, and then we're going to leave those shows up and just add it to those collection of shows that are all available at pagasleaseattorney.com. So here we are. Like I said, we're in May and June, and my older son just came back from school. And so what I have him doing, we were falling a little bit behind on the shows, and what we do is we index the shows. And so we say, like, if you were listening to or you wanted to hear a pipeline show, like we're going to talk some pipelines here today. Very important stuff today we're going to talk about. So if you want to hear about pipelines, you're faced with a pipeline agreement, or your neighbor gets one and you're thinking, hey, I may have one coming up, and you want to learn more about this. I've done many shows on pipelines, and I say that you got to make sure, too, all these shows are for general information, nothing specific for you and your circumstance. So you want to make sure that if you're listening to a show that it's kind of up to date, because we've seen a lot of transition in these pipeline prices, and a lot of my clients now are getting so much more money than what we were able to get them even just last year and certainly in the last few years. So you need to make sure that you're maximizing these agreements. You're maximizing it for financial compensation, but you're also maximizing the agreement for future protections of the property. When is this thing going to terminate? And I'm going to go through a pipeline addendum that was offered by this company in response to something I submitted. And I think you're going to find a lot of this stuff is very interesting. And, I'm going to get into some details, so I'm going to hold off on the details of this. But I really stay tuned. And the shows I do also, they're designed for, today we're going to talk a lot about pipelines. But at the same time, these same principles apply whether you have a storage agreement, whether you have a gas lease presentation to you, a water withdrawal agreement, working on all of these things right now, whether you have an amendment and modification. These concepts transfer over. But remember, it's not a specific advice for any single person. So anyway, back to what we're doing is we're indexing the shows, and we fell behind. I was saying my son came back from school, so I got him working here this summer. And you always sit there and you say, hey, I want my child to listen to me. I want my child to listen to me. So one of his projects that I have him on now is literally listen to me. So he's going back and he's listening to some of the older shows and he's indexing them. So we should be catching up to speed pretty quickly, especially if he's doing his job. So we'll have those shows and we'll have them all indexed. They're indexed, but we fell probably behind about 5 or 10 shows, so we're catching up on that. So if they're not up there, you know who to blame. I am Attorney Doug Clark. This is All Things Marcellus. And again, we're here every Sunday from 8 to 9 a.m. So I want to talk about some pipeline issues today. And before I do, I want to just because I'm going to be prepared every single week. I'm going to hit on the royalty issue and this issue of post-production costs. And I want to say, and I'm going to leave it at this today, there's a proposed settlement that we're out there contesting. And like I said, we have at this point, I think we just went over the 160 individuals who we're representing with well over 5,000 acres. And we're intervening and we're challenging the proposed settlement that Chesapeake entered into in federal court with the Demchak plaintiffs. This is a case called Demchak versus Chesapeake. We believe that settlement is inappropriate. We believe that the values are much too low. We believe that the release, and what a release is whenever you enter into a settlement for anything, if you had a car accident, or maybe if a pipeline company cut trees down that they shouldn't have, and you reach an agreement for a payment in exchange for something. So what I mean by that is you'll sign a release in saying, here, make it super simple. Say the company said, we're going to give you $1,000 for this tree that we cut down. Now, that's obviously a little bit high. Unfortunately, we're not seeing $1,000 trees out there. But say they're going to give you $1,000 for a tree or trees that they cut down. So you say, okay, you know what? I accept that. I'm agreeable to that. Well, what they'll do is they'll give you a release in exchange for this $1,000 payment. And that release says something to the effect of, and there's a lot of legalese in these typically, but it'll say something to the effect of, hey, in exchange for this $1,000, you are now going to agree that you're never going to make any other claims for me, company, damaging your trees or cutting down your trees. So it's just documenting you received this money. In exchange of receiving that money, you're agreeing that this whole matter is resolved and closed, that this is done. So that's called a release. And you have those in every type of settlement. If there was a car accident, similar thing. You would sign a release in exchange for the compensation to fix your car. And you would say, okay, you fix my car. I'm not going to sue you anymore. I'm going to drop the lawsuit. I'm not going to pursue any other claims against you. We're calling it even. This whole thing is closed. Well, one of the issues that we have in this proposed settlement is, and it's a major, major issue, is the release that's a part of this. What are you giving up if this settlement goes through? And another point I want to stress is that there's a preliminary proposed settlement here. It has not even been preliminarily approved. So we're at a very critical stage in this process. This was submitted at the end of August, early September 2013, and it's still in front of the judge, and it's not been approved even preliminarily at this point. And certainly we believe that our motion to intervene and the fact that we represent all these individuals who are opposing it is obviously stopping or slowing down this process, and it's getting a lot bigger and better look, which is absolutely necessary. So there's been articles out there that this settlement has been approved, and unfortunately the first article got it wrong. And it's funny because it seems like every other article I ever read just copies that one section from the first article that first reported on this proposed settlement and indicated that it was approved and it was been reached. And what it is simply is a proposed settlement that's been submitted for preliminary approval for this class of individuals who are leased in whole or in part to Chesapeake, that have this, what we call the market enhancement clause or similar language, and that the agreement requires that Chesapeake will pay 55% of money of post-production costs that they've withheld under leases with this term up to September 1st, 2013. After September 1st, 2013, moving forward, instead of Chesapeake deducting 100% of these costs, like gathering, transportation, compression, for example, under the terms of these particular leases, and there's thousands of them out there, what they're saying moving forward is instead of deducting 100%, we now will deduct 72.5%, such that the landowner is going to receive 27.5%. So that's the proposed settlement outlined as far as the financial terms. Now, there's much more than that, but the financial terms are basically those. Now, also, though, in the settlement is a release. So, and remember, this is a proposed class settlement. So you may be a part of this and you're not participating in any fashion. And that's why I say, we want to make sure that you understand. There are 13 individual plaintiffs in this proposed settlement. And so it's very important that you become educated, informed, and understand what are the terms, and do you want to be a part of this, or do you want to object to it? Do you want to stay on the sidelines? What do you want to do? And that's an individual decision that you should make based on information. So, release. I'm finishing this up. In the release, there's language which we find very troubling, and it involves the ability of the landowner to do an accounting or to challenge royalty calculations in the future. And you got to be very careful because this language is going to greatly limit, if not just preclude, the inability to do any challenges in the future. So you may be solving, if everything was perfect, this one issue, but are you also giving the company a free pass for future issues? So that's very troubling language. Now, another point is a lot of people are aware of this House Bill 1684, which is a proposal, it's legislation regarding the deduction issue. I'm not going to go too far into it now, but my point is, if that were to pass and that were to benefit you and you were part of this class, or there's other future legislation that passes, you need to know that the release seeks to preclude that type of benefit from applying to you. So that's super important, very, very important. And so now we see legislation that's out there. So we see this is a real deal. This is something that can occur. So we need to make sure that you as a landowner are aware of that, and that you're aware of what these terms of this release are. And even if you like the financial terms, which we certainly absolutely do not, but even if you did, what are you giving up in exchange for that? You can't just look at one thing. Of course, we see this financial terms as very weak and inappropriate, but there's more to that. There's more. I'm way over. I am Attorney Doug Clark. You're listening to All Things Marcellus. I'll be right back after this break. Welcome back to All Things Marcellus with me, Attorney Doug Clark of the Clark Law Firm. And a reminder, we're here every Sunday from 8 to 9 a.m. And you can go back to pagasleaseattorney.com, pipelineattorney.com. Great information available out there on the websites. Just check it out. Go there anytime. We will have the radio show archived and indexed so you can go back and check out the show that interests you. We're going to have, we do have about 150 hours of radio shows available. I've been doing this since August of 2010. So we have these shows archived at pagasleaseattorney.com. Go check them out there. I want to finish this last thing I was talking about, and it's such a very important issue, this royalty deduction issue. And I talk about these prior shows. There are many shows that I've done dedicated to this issue or we touch on this issue. I'm going to talk about pipelines a lot here today, so I want to get moving on, but I want to remind everybody that, again, if you don't know what's going on, and if you do not know whether this whole situation applies to you, I offer everybody out there a free, confidential, no obligation review of your lease. And if you're getting royalties, send me a royalty check from the companies that are paying you, and I'll let you know whether I feel that this action applies to you and whether I feel that you have a claim against the gas company for inappropriate payment of royalties under the terms of your lease. Now, also, very important, you do not even need to be receiving royalties yet for this situation to apply to you. So if you're leased in whole or in part, because now many companies will typically, in a lot of cases, hold your gas lease. And what I mean by that is that you may have signed with one company, and now, say you signed with Chesapeake, but now Chesapeake shares your lease with a company called Statoil, maybe with Anadarko and Mitsui, maybe even others. Maybe you signed with Chief, but now Chesapeake holds your lease. It's very important that you understand this, and a lot of people don't get this, but even if you're not receiving royalties, if you have the language in your agreement, this market enhancement clause or similar language, if you have that in your agreement, and even if you're not getting royalties, this situation and this proposed class action settlement will apply to you. You need to understand that. And so if you don't, or if you do, you want more information, you can always contact us directly. I do, again, free, confidential, no obligation. You send it in, I write back to you and say, hey, look, believe this applies to you. And what you do with that information is entirely up to you. Usually get back to people within 7 days to 10 to 14, usually at the max. I do them on the weekends a lot. So send me this information. I want to let you guys know, as I said before, we represent currently over 160 individuals in the opposition to this proposed settlement, and in the proposed settlement, there are 13 individual plaintiffs. So, we really feel that, obviously, from our perspective, certainly we're against this proposed settlement, but we feel that, the community's out there speaking. So you really need to understand that this is truly a $100 million plus issue, and potentially even into the billions. So you really need to understand this and how it may impact you. What you do with that is your decision, but you really should understand, does this apply to me? Everybody should understand that. And I talk to people, every week where they come up and say, oh my heavens, I didn't even know about this. So, if you don't know, talk about it, get it going out there. If you have neighbors that may be affected, friends, just get the information. If you say, hey, I think this is a good deal, then support it. But get the information. Too many people are uninformed, and I think too many people are afraid to get that information. So again, call me anytime, 570-307-0702. Go to the website, pagasleaseattorney.com. We break down the critical terms, the key terms of the settlement at pagasleaseattorney.com. Go check these places out. Very important that you get informed. I am Attorney Doug Clark. You're listening to All Things Marcellus. Again, we're here every Sunday from 8 to 9 a.m. and you can go to pagasleaseattorney.com and you can listen to this week's show starting Monday morning and all other shows. We're also, just a reminder, we're also on iTunes. You can go to podcasts for free. Go check that out there. You just type in All Things Marcellus, and you can listen to them, listen to the prior shows through iTunes. And check us out on Facebook. And you can follow me at Twitter at Doug Clark Law. What I do there is usually I'll be tweeting articles that I find are of interest that I think will be of interest to Pennsylvania landowners. And a lot of things too, it's really neat for us. And I invite anybody out there, you can send me articles or you can send me information that you think may be useful, that you'd like to hear me talk about on the radio show, or you think maybe a good article for me to tweet out there to the community. I have a few people, Linda, hello. But I have some people out there who will send me articles, and I love that. We go through them, I read them. Can't always read them the day they come in, read them on the weekend, but read these and we'll tweet these out and we'll get it out to people, sift through and say, hey, I think this is a really good article that people need to know about. So I look at ourselves too, a lot of times I look at myself in the office as kind of this hub where landowners supply us information and then we distribute that information out to the community. We want and I want people to be informed and educated because that's how you make good decisions for yourself. That's how I would want to be. That's how I would want my parents and my grandparents. We want you to be informed and make good decisions for yourself. So whether you're calling me or calling somebody else, make sure that you're getting good quality information. Okay, I'm going to turn the page, and we're going to talk about pipelines. And I talk a lot about them in the last few shows that I've did on pipelines. Talk some of these bigger picture ideas. And I'll say this, and I'll get into some details here. But I want to say, please, if you're approached with a pipeline right-of-way agreement, please get assistance. Please get assistance. You can call me or call somebody else, but get assistance. We are seeing numbers. I have clients where their final agreement that they sign, and this is obviously not every case, but I have clients who go from $30,000, $40,000 offers to over $100,000. Sometimes, rare, over a couple $100,000. You have to understand your leverage. You have to. It's not just about compensation. But if you're a person who can get an increase from, say, $30,000 to $100,000 in an agreement, if you're able to do that, just think what you can do with the other terms of your agreement. And believe me, the land guys, the company representatives, here's my part every week, ask them to show you their card. Where's your business card, sir? Ma'am, where's your card? Whose name is on there? It's not going to be your name. They do not work for you. They work for the pipeline or gas company or whatever company they're out there to get an agreement. And so when they're giving you information, quite frankly, sometimes it's just wrong information. Sometimes it's partially true, but it's very, very misleading. That's why you need to have a representative who is experienced in these issues to help you. The help that you get, the reward from that help, the result from that help may be very, very substantial. And a lot of times it is. A lot of these companies, we're able to increase option payments or payments up front that more than offset any attorney fees that you incur. So you're having an opportunity to understand your agreement at a much different level, that you really understand each and every term. You're no longer intimidated by the process. You're informed. And at the end of the day, there's a really good chance that financially and you've benefited, and sometimes you benefit substantially. So it's so important that you get this assistance because some of these pipeline agreements, you have a tremendous amount of leverage. I have one today that I'm working on, that I'll actually be working on later today. where the number that was started compared to the number that's going to end up being the result, it's about 7 times higher. And it's very substantial. And it's because we were able to evaluate, determine the leverage, and get the best possible deal here. So you have to understand your circumstances. Now, at the other time, and I talked before, other times you may have what's being requested is a straight well line, a line off the property to a well on your property. Well, if that's the case, we have limitations as to what we can do. And the first thing I would tell you is, hey, look, we have some limitations here. You don't have a lot of leverage, so let's do this. Let's make sure that we're limiting the pipeline to go only where they tell us it's going to go, only where they need it. Let's limit it. Let's get in and out with the best possible agreement, because we've dealt with these companies almost virtually all before. Let's get in and out and maximize your agreement, but this isn't negotiation of world peace here. However, in other cases, I'm working on a case right now, a couple of them actually, where a company wants to get to a power generation plant. They have no right in the world to go across my client's property. They really need to go across this person's property because they lack alternatives. So that puts this individual in a very strong leverage position. Now, they're in a strong leverage position, and they also have to look at, do I even want to do this? Because not everybody wants a pipeline. And I certainly understand that. And many times when a client calls me and I look at this situation and I see that the offer doesn't appear to me to be a strong offer, that they have the ability to say no, and the company is saying we're not going to be flexible on the financial part, I say, well, why are you even considering this? Can you tell me, why would you want to do this? So a lot of times I end up kind of talking the client out of the agreement, and it's not really talking out of the agreement, but what it is really is to kind of open everything up, to explain what the options are so that you can really see what you have and what your alternatives are. You really, anytime you're going to make a decision, you want to know what your alternatives are. You want to have the complete picture. So you may decide, you know what? This isn't right for me. And maybe you're in a situation, I have a client now who there's a proposed roadway across that property. The roadway is not going to pay them a whole lot of money. Let me give you these hypothetical numbers so they're not too close to the actual fact. So let's say this, though, and this is a very real situation. Company says, hey, we want to put a roadway on your property. We're going to give you $25,000 to put this roadway on your property. However, this roadway is going to stay on your property as long as we have this meter site or this valve site, or as long as we have this site on top of our pipeline, which is going to be essentially as long as that pipeline's in the ground. So we now need to look, pipelines. I'm working on one of an outstanding client that I've had for a while. The pipeline agreement dates back to the 1800s, to the late 1800s, but the 1800s. So let's come into this and say, this roadway is going to be there as long as that pipeline is there. That pipeline is going to be there, I would say, at least 50 years, and I'd say more likely over 100 years, based upon where this location is. So you're looking at $25,000 today when you sign, or a couple years even when you sign. But you're looking at this payment now, if they exercise the option. But you're looking at $25,000 now. You're going to have to pay taxes on that. Then that roadway is going to be there for the next 100 years. You're also in a situation where you're probably going to start getting royalties soon. So in 5 and 10 years from now, you're going to see that roadway is always going to be there. That roadway may not be in the ideal location on your property. Do you want to sell for this roadway at $25,000 today? And in 10 years from now, 15, maybe 5 years from now, you're looking at that roadway and you're collecting some nice royalties, and that $25,000 after you pay taxes, that's a memory at this point. Was it worth doing that? Do you want to do that? So we need to not only look at today, but look into the future and say, is this right for you? Or perhaps, you know what? I can go with this roadway, but company, I want the roadway in a different location. I want it to hug the border of my property, so it's not going to impact my future use of the property. And, also, it's not that I'm pushing or dying or fighting to get this extra money, but, I really don't want the roadway. But there is a number. If you want to give me $100,000, well, I can justify the roadway. It makes sense at that point. But it's not about, hey, I'm just in this to try to maximize the money. It's more of, the nuisance, or to have this activity, and it certainly is more of a nuisance, but to have this activity, what is it worth to me? You could say, I would never agree to have a roadway through the middle of my property. And you may have that position and may never agree. Or you may be in a situation where I say, I'll never agree to that, but the company says, well, how about if we offer you, and this is obviously a hypothetical, but they say, well, we'll give you $2 million. Well, maybe that makes it worth it. Maybe the price might be $10 million. Just go ahead, if you're in these negotiations, and say to clients, look, let's get this out of the way early. If you don't want this, let's come up with a number that works for you, that justifies you agreeing to this intrusion and burden on your property. Present it, and if that works, hey, let's move forward with the terms. If that doesn't work, let's move on. Move on down the road, and we'll go and we'll wait and see if anything else happens in the future. Okay, I promise when I get back, I'm going to talk about this pipeline addendum that I received for a client, and I want to break down some of these terms because these are the type of things you need to be thinking about and looking at, and this is typical company landman approach and information and how they present this. This is very, very typical. I'll be right back. You're listening to All Things Marcellus with me, Attorney Doug Clark. We'll be right back after this break. Welcome back to All Things Marcellus with me, Attorney Doug Clark. And a reminder, we are on these stations every Sunday from 8 to 9 a.m. And also you can go check out the website, pagasleaseattorney.com. pagasleaseattorney.com. You can check out all the prior radio shows. I've been doing the show just recently in the new stations, but I've been doing the radio show since August of 2010. So if you're just hearing for the first time, you can go back, check out the websites. We have a show guaranteed that fits into what your needs or your concerns are. Remember, these shows are designed as general information, getting landowners thinking, getting you information you need to know in this process. You need to know this. So check out the shows. You can go anytime. You could also go to iTunes even, and you can download the shows that are in the podcast. Just type in All Things Marcellus. But go check out the shows. I think we're real close to 150 hours of radio show. You can go check them out at pagasleaseattorney.com. Also check out our sister site at pipelineattorney.com. Great information there. You really should come up to speed with this. Even if you already signed agreements, even if you don't have agreement in front of you, you're considering, go check these things out and things you need to be thinking about. I'm going to get into this pipeline, but what I want to say too is I tell all my clients and frankly, anybody out there, if you're presented with an agreement, you can send me anything and I'll look at it and I'll say, hey, look, you may want to have some assistance on this. And then you don't have to do that. I mean, whatever you decide to do is up to you. But I know there's landowners out there and you get intimidated, and landowners get intimidated and they're afraid and they don't want to call a lawyer, or they haven't dealt with lawyers. Please be comfortable. You can call us anytime. We'll give you some information. And then what you do with it, again, is up to you. And this isn't just a big sales pitch. Hey, call me. What I'm saying is, really, I don't want people to feel that they can't reach out and get some information, that it's not a comfortable process, because I believe we do, and that's one of our strengths, is to make this process as comfortable as possible for the landowner. So if you're given a pipeline right-of-way agreement, again, remember who's giving it to you, the company and the company representative. If you're given a gas lease, an amendment and modification, give us a call, look at it and say, hey, yeah, this is something you may want to get some assistance, and here's what we do. If you want to do that, that's great. I never harass or pressure anybody. Going back to the first shows, there's no pressure. You should never be pressured. What you should be is informed. So please never feel afraid if you're given anything to sign. Once we have a client, any future time, they send me all their documents and say, hey, look, is this something I need your assistance with? And sometimes it's, hey, yes, whoa, don't sign that. Here's why. And sometimes, hey, yeah, this is not that big of a deal. Here's what the document is. I have no objection to you executing it. There's nothing that I would see that I would recommend that you change here, but that's your call as well. So be informed. Don't be afraid to reach out, and you can call me anytime, 570-307-0702. That's 570-307-0702. And I have clients all across Pennsylvania. from the northeastern part to the southwestern part, and clients all across the country, and actually even in other countries who own property in Pennsylvania. So don't be afraid about distance too. You can reach out and we'll let you know if we can help you out and whether you're comfortable in moving forward, and it's always your call. I am Attorney Doug Clark. You're listening to All Things Marcellus, and a reminder again, we're here every Sunday from 8 to 9 a.m. Okay. What I want to talk about is a pipeline right-of-way addendum that I've received. And this is a client where we have a decent amount of leverage. And in fact, the offer has gone up substantially from what the first offer was. And it doesn't always occur that way, but many times it does. So what happened here by way of history, and this has been going on for a little while, and typically too, when negotiations go on for a little while, it's because we have leverage and there's things that we can do. If we're limited in what we can do, like I said earlier, we want to get in and out. We want to be efficient. I'm not here as an attorney to give you a big legal bill and you say, what the heck did he do for me? If it's going to be something that we're limited, we want to get the best possible agreement. We want you to be informed, but we don't want to make this into months and months and months of representation. We want to be efficient. We want to inform you, but we want to get in and out. Now, in this case, we had a lot of leverage, and there were a lot of issues that the clients had, and rightfully so. The agreement that was presented was a very, very friendly company agreement and very poor for the landowner. Very poor, as most of them are, almost all of them. This one, though, was exceptionally problematic. So I write back to the first representative and say, hey, look, my client's not crazy about these terms. We'd like to have additional compensation. So we go through this compensation process. And then we get to the point where after conferences with the client, we say, you know what, look, I'm going to list for you these 7 critical factors and this amount of compensation that these items have to be met. And if they're not met, then we're done here at this time. So just go ahead and move on. If you can meet these 7 terms, then we're prepared to go ahead and keep talking. But this is it. These are threshold issues that you have to meet or we're done. And it's okay. We're just moving on. And we do not want to spend more time, effort, and money in this process if you can't meet these issues. So this is it. You say yes to these things, and then we can move forward to some other points. Well, I had previously sent out some other concerns based upon the first offer as well. And after, and here's what happens is, so the company's like, well, geez, we don't want to meet these terms. So they go out there and they see if they can find any other alternatives to see what else is out there that we can maybe find that we don't have to deal with this or enter into or continue with these negotiations. Which, again, our clients are aware of, my clients are aware of, and they say, okay, we're willing to take this chance, if you will, and if they bypass us, that's fine, because we're not going to agree to a bad agreement simply to agree to something. It just makes no sense. So after a couple weeks, they write back, okay, yeah, you know what? I think we're going to be able to really work with you guys. I have to run some things by some other company people, but I think we can really do things. A couple weeks later, same type of thing. Hey, things are going really well. Sorry about the delay. Now, I know that there's a really good chance what's going on behind the scenes is they're looking for alternatives. So my thing is, hey, that's fine. Just let us know. We're not spending any more of my client's money negotiating back and forth. If you want to meet these terms, that's great. Well, about 6 weeks later or so, I get back an email and some updated documents saying, hey, really excited. We think we really incorporated all your concerns here, got everything covered. Sure, your clients are going to be really happy. Hey, please keep this confidential because nobody else is getting this type of money. Now, I'm not going to talk about the money here, but keep that confidential. So I said, okay, all right, fine. Let's look at these documents and let's see what you did. You told me what you did. Now let's go ahead and actually look at the agreement and see what you did. So I'm not going to go through each and every term, but I want to go through some of these terms that are very problematic. And let me say this. Of the 7 items that we had indicated and the compensation that my client requested, the company met 1 of the 7. They write back and say essentially, oh, we got all these things covered. Well, they actually only met one of the 7 items. And it's funny to me. I said, do you think I'm not going to read this? Do you think my clients are not going to read these things? They meet one. And that was a location issue as to where the clients wanted the line. So they met that. But the reality is we already kind of knew that they were going to do that from other discussions. So that wasn't, a major event or a major concession, because we knew that was going to occur from other discussions. The compensation, they didn't go to the compensation figure we requested. They went half of the distance. For example, and these weren't the numbers, but say they were at $10 and we requested $30. And they come back and they say, well, we'll give you 20. So it was that type of thing. They split that difference. So it was kind of funny because they said, look, if you can't meet this number, keep on moving. So they come back and say, okay, we think we got everything covered. So they didn't meet the compensation number. Then we get into some of these other terms. And one of the things the clients wanted in this case was one pipeline only. So what do they come back? They say, okay, listen, we acknowledge we can't meet that. We need to have the right for 2 pipelines. So when they send back the term, here's the pipeline term that they sent in the addendum. Grantor and grantee, so landowner and company, mutually agree that this agreement shall not prohibit company from laying multiple lines. However, grantor shall be compensated for additional lines at the same consideration, or money, and damages, money, rates as described in the original agreement. Well, a couple things there. Number one, okay, the damages and compensation. What they're saying is if they lay a second line, then they'll pay that same money again. So hypothetically, if they were paying $25,000 or $50,000 for installation of the first line, they would pay that same amount of money if they were going to install a second line. However, although the email says we need the right to lay these 2 lines, well, the actual document says grantor and grantee agree that the agreement shall not prohibit the company from laying multiple lines. So they didn't limit themselves to 2. They could lay lines forever. They could put 3, 4, 5, whatever they can fit in that easement. So that's just something is, how important is that to the landowner? Because each time they come in and put a line in, maybe they're not clearing the trees that they're doing the first time. But what they are doing is digging that trench up. They're doing all that excavation work. Then they have to do the reclamation work. And, reclamation doesn't always occur like they say it's going to occur. So each time you're going through this construction process, yes, very important that you're getting at least the same consideration or same money the first time. Critical. But do you want to limit how many times this can occur? Also, do you want to limit for how long this can occur? So say they're giving you $25,000 to put a pipeline in today. Then they come back in 20 years and they say, we're going to put another pipeline in and they're going to give you another $25,000. Well, we don't think that $25,000 is going to be worth as much in 20 years as it is today. We see some of these ones from the 50s where they're paying like $1 a foot. So we want to make sure that if we're considering what can occur in the future, and should there be any escalators, ways in which that you can get more money in the future if there's going to be future lines. And also, we're looking at, do we want to limit to only 2 lines? I'm told in the email you only need 2 lines, but the documents say something different. And very often, landowners, please, very often no, being KNOW, that occurs all the time. What is said to you, what is presented in the cover letter or cover email isn't necessarily the way it's written in the contract. You must look at the contract. These contracts almost always have this language saying that the contract essentially is the contract. No other writings, no other oral statements apply. Only what you're signing and what's written on this document. Okay, we're up against, I have some short segments, so I'm going to take a break now. We're going to talk more about some of these other agreements. I'm going to talk about the pitfalls of mutual consent not to be unreasonably withheld. That's mutual consent on something for the landowner has to consent, but they cannot unreasonably withhold that consent. We're going to talk about that and how the company's using that to really do whatever they want, in my opinion, in this agreement. I'll be right back after this break. You're listening to All Things Marcellus with me, Attorney Doug Clark. Welcome back to All Things Marcellus with me, Attorney Doug Clark. And a reminder again, we're here every Sunday from 8 to 9 a.m. And, I do it all the time. I have a short segment here at the end, so I'm going to get to what I can. But, boy, I could talk about this agreement probably for a couple shows, and I'm sure I'll be bringing this one back up. But I want to talk about, we're talking about pipelines, and I want to talk about this term of mutual consent not to be unreasonably withheld. Now, this language appears all the time in gas leases, pipeline agreements, on a lot of different documents. And sometimes this language can be very helpful. Sometimes, in my opinion, it can be meaningless. As always, the key is to understand which time we're in here and what are we looking at in the future. So sometimes you have mutual consent not to be unreasonably withheld that can really work out to your benefit. So when a company approaches you, say to put a well site on the property, they come and they ask for your consent and you say, you know what, I don't want it there. I don't like that location because of these reasons. Maybe that's the only place where you have a field that you're farming. Maybe that's right out the front window that you have to look at it every day, and you can provide them some alternative locations and say, I'm not going to consent to this location, and this lack of consent that I'm giving you, I'm taking a reasonable position here. This is reasonable, and here's the reasons why. And in that case, the company very often will say, okay, let's look at these other areas and see if we can operate there and go ahead and move the site. Now, it doesn't always work that way, and we're giving an example of reasonable reasons, but sometimes landowners say, you know what, I don't want it there, 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 and they don't have any good reasons as to why they don't want it in these places, and they entered into an agreement that allows this activity, so you got to be careful. And sometimes those landowners, even though they have this provision, say, boy, that provision was worthless. And certainly sometimes maybe you do have, and I would agree that you as a landowner have a reasonable position, or you've presented good reasons why you shouldn't consent, but the company disagrees with you, and now you have another problem. What's going to happen from there? So we're looking at that. Sometimes, though, that's the best you can do. And if that's the best you can do, you're certainly better off having that language than not having it. But other times you can do better. Other times you can do better, and you need to know when that is. So in this particular case that I was talking about before, the company writes back and says, oh yeah, we've met all your concerns. And like I said, we had 7 threshold concerns, 7 issues. If you can't meet these issues, then we're not going forward. So they say, yeah, we've met them all. Well, one of the issues that we had was, look, no above ground facilities or structures are allowed in this right-of-way easement, that you can't have a valve above ground, that you can't have a pig launcher, a receiver, some sort of metering site. You can't have anything above the surface of the ground. You can have a pipeline under the ground, but nothing that we're able to see above the ground. Very, very important in this particular case. So let that known. If you can't do that, move on, please. We're not going to be involved in these negotiations. So I get it back. Hey, yeah, we can do this. We're going to meet all these terms. So here's the language that I get in response to the no above ground structure request as a threshold issue. And I promise you, this gentleman knew very clearly from a long period of time of talking to him before that this was a serious request that must be met. Well, the response I get back then is this. A clause saying that there will be no above ground appurtenances. It says that company agrees that there will be no above ground appurtenances and or facilities placed upon the right-of-way, with the exception as required by law, cathodic protection test stations and signage and markers without further consent of grantor. Okay, so let's break that down real quick. Company agrees no above ground appurtenances or facilities unless required by law. Well, okay, signage, things like that, a sign at a river crossing or a road crossing or something along those lines. Okay, that's reasonable, and certainly if you're required to do that as a company, then you have to do that. But you're not going to be required by law to have this pig launcher or facility on this property. So, okay, and that's pretty standard and that's acceptable. So it says again, breaking it down, company will have no above ground appurtenances or facilities without the further consent of landowner. Next, last clause. Such consent shall not be unreasonably withheld. So we can't put anything above ground on your property without your written consent. However, your consent cannot be unreasonably withheld. Well, that's it. That's the killer language here that's not going to make this whole thing fly in this particular term. And the fact is they're going to end up caving, I'm certain, and say, okay, we don't need to do that. But we have to read these documents, because what this is saying here is that we can't put anything there, but if we ask you to put a valve site, to put a pig launcher or a receiver, you can't be unreasonable and say no. Well, what if you have a dispute? What if you say, first off, number one, in this case, the landowner and the client said, we want nothing under any circumstances above ground in this right-of-way area. Nothing. Company says, okay, yeah, we can meet that. Then they send us this term, clearly not doing what they represented that they were going to do. Okay, so that's first and foremost. Then we get to, all right, well, what does this mean? Well, in the future, company knocks on the door and says, hey, we want to put a valve site, a pig launcher, a receiver. We need to have something above ground in the right of way. And you say, whoa, company, you said nothing above ground. We told you that. They say, well, read your agreement. That paragraph says that we can put it there. We need your written consent, but you can't be unreasonable. So we need to put this there. And they say, no. Landowner says, no, I don't want it there. Company says, well, you're being unreasonable. We need to put it here, and what they'll like to say, and of course, who's not against safety, we need to have it here for safety reasons, to safely operate our system. We need to have this here for safety reasons. And you're being unreasonable. Well, what does the landowner do then? If you're in this battle and you say, no, I'm being reasonable, company says, no, you're being unreasonable. Well, what do you do at that point? Company says, well, we're going to go ahead and install it. Landowner says, no, I don't want it there. Well, what do? Well, you're going to have to do something legally to stop them. Are you really going to file an injunction? Are you going to go into court and file an injunction and hire an attorney and spend all of this money to fight the company on a position as to whether you're being reasonable to try to block the installation of this facility? Now, remember, they may say, okay, fine, we won't put it here, but give us an alternative location on your property. And you say, I don't want it on my property. And they say, well, you're being unreasonable. And that's probably going to be a fight that you're going to lose. But even if the unlikely event that you could fight this and win, especially on the alternative location situation where the company says, okay, well, we won't put it here, but we're putting it somewhere. And if you're going to fight that, and you have to go into court, that is going to cost you thousands and thousands of dollars. The company may force or seek to force to have you post a bond, to put up money to challenge this if you have to file an injunction, because they're saying you're causing us irreparable harm that we can't repair because we need to do this now. And by slowing us down, you're costing us money. And if you're seeking an injunction, you have to post a certain amount of money. In my experience, very few people are in a position to go into court or have a desire to go into court on an issue like this. And very rarely could I recommend that you do that. You really got to look at the circumstances, but that's a very rare situation. So what do we have then? In my opinion, we have a clause that allows surface structures in the future. You may have some input where they're going to be located, but they're going to be there if the company wants to put them there. Despite this being one of the 7 critical issues saying if you don't meet this point, we're done. There's no sense talking anymore. They write back, hey, we're able to do all these things. Remember I said before, and I'm not going to be able to get to them all, of the 7, they only actually met 1. They only met one. And in this particular case where we said nothing above ground, they act like, they present it as, we've met your provision, we met your request. We're giving you an agreement that does not permit anything to be installed above ground. That's the representation orally. That's the representation in the cover email when they send the documents. That's what's being represented. But what's being delivered? What is being delivered? And this is being delivered to me as the attorney. I've dealt with 50 pipeline companies in the past. They have the nerve, they have the confidence to present this to me, somebody who sees these every single day. So think about what they're giving to landowners out there. So they present to me, telling me, okay, we met your provision that we can't have surface structures on the property. But the document says, no above ground or structures or facilities on the right of way without your client's written consent, but such consent shall not be unreasonably withheld. So if that knock comes to your door and they want to put an above ground facility on that property, there is going to be an above-ground facility on that property, despite the representation saying that they met our request and wouldn't do it. All right, we're up against it. This is All Things Marcellus with me, Attorney Doug Clark. Reminder, check out pagasleaseattorney.com. We'll have the show up tomorrow, and we'll have all the shows there. Have a great week, everyone.